Copyright Infringing File Sharing Amendment Bill. Before I start, I wish to acknowledge the great efforts put into the bill by the Minister responsible for the bill, the Honourable Simon Power, and also the Honourable Leon Dazelle, the wonderful chairperson of the Commerce Select Committee. It's not easy. It's a great compromise. I'd like also to thank my learned colleague, Labour's Communication and IT spokesperson, Claire Karen. Her press release dated November the 3rd, 2010 was so good that it has been well read by both the stakeholders and interested parties. Due to a last-minute compromise between Labour and National, New Zealanders will have their internet connection terminated as a result of proposed new copyright laws. This compromise means that termination of internet access as an ultimate penalty for repeat copyright infringement remains in this bill, but cannot be enacted unless the Minister makes the decision to do so. The Minister would have to enact the termination clause by order in Council, which puts the onus on the creative industries to prove there is a case to terminate access for internet service providers to ensure that the system of providing deterrent notices to copyright infringers works, and on the Minister to ultimately make that call. Without this compromise, Labour could not have supported the bill. The compromise is important, realistic, and well warranted, but I do acknowledge the points raised by Mr. Gareth Hughes, and I look forward to seeing what his SOP has to offer at the committee stage. But I do agree that we are dealing with the real world, we're dealing with the reality. In this world, in our modern daily lives, internet access is fast becoming as necessary to us as the provision of morning or evening newspapers, or as important as television, cell phone, water, or electricity. The purpose of this bill is to establish a regime that deters file sharing that infringes copyright, educates the public about the problem, compensates copyright owners for damage sustained from copyright infringement by file sharing, provides sanctions for serious copyright infringers, and limits ISP liability that may result from account holders infringing activities. So it is largely about education and deterrence. Much has been said about the controversial Section 92A and the widespread objections it has attracted. Some submitters at the committee hearing describe it as guilty upon accusation clause. The bill repeals Section 92A and replaces it with a three-notice regime backed up by $15,000 fines and 6-month internet suspensions. Minister Powell described the three-notice regime as the major feature which educates the public about illegal file sharing and provides effective methods for copyright owners to enforce their copyright. It ensures that infringers are given adequate warnings that unauthorized sharing of copyright works is illegal. The three-notice regime, despite its gentle name, seems to have won wider support as an effective mechanism. It is believed to be more effective than the much-hyped three strikes regime. Following his wonderful submissions, Judge David Harvey informed us that a survey in France in 2008 found that 90% of users would stop illegal file sharing after 2 warnings from their internet service providers. Judge Harvey also made available a copy of the 2008 Digital Music Survey conducted by Entertainment Media Research in the UK. This survey showed that 70% of users would cease infringing activities after one notice from their ISPs. And in our local context, the Young New Zealanders and the Movie Downloading Survey found that more than 70% of respondents in New Zealand would cease infringing activities if they received a letter from their ISP. I thank Judge Harvey for his contribution. I remember my early university days in Auckland. I had the privilege of studying the IT law under Judge Harvey. The class started at 8 o'clock in the morning, and Judge Harvey, who's always energetic and thoughtful, would have to rush to the city campus of the University of Auckland and 2 hours later rush back to the district court in Manukau. Judge Harvey is New Zealand's most tech-savvy jurist. His submissions enlightened me, enlightened us, and I thank him for his great contribution. Submissions from TradeMe, 2 Degrees Mobile Limited, New Zealand Film Commission, Internet New Zealand, Computer World, and the University of Auckland are good too. The University of Auckland, in its submission, raised some important issues. Among others, it had 2 serious concerns. The first one is the bill as worded is not consistent with the explanatory note. And secondly, it argued that if universities, libraries, schools, or seminar organizations are excluded from the definition of ISPs, they are potentially liable as account holders. I note that the Commerce Committee report where it recommends the term ISP, i.e. Internet Service Provider, be replaced by the new term IP-AP, which is Internet Protocol Address Provider. I look forward to discussing in a more detailed way about the matter and more specifically relevant sections such as 92, 29 and 122 at the committee stage. Labour is prepared to support this bill through its remaining stages due to a compromise we reached with National, as explained by my learned colleague Claire Curran, who took the first call on behalf of the Labour. This compromise means that suspension of Internet access as an ultimate penalty for repeat copyright infringement remains in the bill, but cannot be enacted unless the Minister makes the decision to do so. Labour's preferred option was to completely omit account suspension because it is draconian, unnecessary, and would not work. Now that account suspension remains in this bill and it could theoretically be used in the future, but any minister who implements termination will have to wear the consequences. Rather than oppose the bill outright, we prefer to compromise to ensure New Zealanders are not denied access to the Internet, something which many people heavily rely on nowadays. Thank you, Mr. Speaker.
The question, Mr. Young, you're seeking a call. You have it. Jonathan
Mr. Speaker,
Young.